Searches and Seizures, United States versus Leon.
In 1981, the Berkeley Police Department in California received a tip about a house that was conducting drug trafficking. With the tip, the police department started to set up surveillance. During that time, they suspected 4 individuals to be involved in the operation. The police department then submitted an affidavit for a warrant. The affidavit was reviewed and signed. The police department then executed the warrant, and Albert Leon was arrested. He was indicted for a federal drug offense. However, Leon submitted a motion to suppress the evidence because he believed there was not enough probable cause for a warrant to be issued. The case received an evidentiary hearing. The district court granted the motion in part, concluding that the affidavit was insufficient to establish probable cause. The court did, however, realize that the police officers were acting in good faith. The court still rejected the government's request to not apply the Fourth Amendment. In other words, the court did not side with the government. The Court of Appeal upheld the same decision as the lower courts, and then in 1984, the case went to the U.S. Supreme Court. According to Hess, Orfman, and Kingsbury, the U.S. Supreme Court specifically addressed the issue of whether the exclusionary rule should be modified. So evidence obtained by an officer with a warrant later found not to be based on sufficient probable cause could still be used in court at a trial. What's impactful about this case for the criminal justice system is that the U.S. Supreme Court ruled that the exclusionary rule only applies to police misconduct. In this case, it was the magistrate that signed off on the affidavit. Therefore, the police were only acting in good faith. Therefore, the mistake was made by the magistrate and not the officers.
So those types of evidence can be used in court.
The U.S. Supreme Court provided 3 scenarios in which the exclusionary rule could still apply. The first scenario would be that the magistrate did not act as a neutral or detached party when they issued the warrant. The second scenario would be that the officers were dishonest or reckless when they submitted or prepared their affidavit. And the third situation, according to Hars et al., the officers could not have harbored an objectively reasonable belief in the existence of probable cause. This case right here established the good faith exception rule to the exclusionary rule, which is what makes it so influential. This case impacts my profession because I know that my work is protected as long as I act in good faith. Well, that's it. Here's my reference page. Shout out to pixels.com and pixabay.com for the videos and the photos.